Dear participants and fellow IPs, at the onset, I would like to welcome you all on behalf of IPNet North in this webinar titled Issues and Challenges in Avoidance Transactions. Today is the third day of Navratri and different forms of Ma Durga are worshipped on each day. The third form of Ma Durga is a day of strength, peace, and protection. Her story reminds us that strength and serenity can coexist, and her blessings guide us towards a life full of inner peace, protection from negativity. With this, we begin our seminar for today. We are humbled to have with us our lead speaker of the day, IP Pooja Bhari. As you all are aware that IP Net North is organizing its first webinar, and it's the third in the series of webinars as organized from time to time by IP Net, which is the National Network for Insolvency Professionals. Moving forward, please allow me to invite IP Vikram Kumar, member of National Executive Committee and Regional Head of IP North, for the formal welcome address.
Thank you, Namrata, so much. And, on this very auspicious occasion of Navratri, I warmly convey my greetings to, all my IP fellows for a happy Navratri. So, it gives me a great pleasure to, welcome you all to our first IPNet North webinar on a very, very important issue on, issues and challenges in avoidance transaction. And we have a very competent speaker in, Pooja, in our colleague Pooja Bhari, because she's also a part of our executive member, of the IP North. And we requested Pooja to take up this issue because we wanted to have a very good opening actually. And, I've heard Pooja speaking on this topic earlier. So I thought this is a good opening for our IP North program. So, unfortunately, our keynote, our chief guest, Dr. Triveni Singh, has not been able to join us today because of his some last moment, engagement. So what we will do, after our welcome address, I will request Dr. Makhija, our president, to speak a little about the IP net, because we will use this opportunity because we have a little 5-10 minutes window. So we would request Dr. Makhija, after the welcome address, to speak on IP net, and maybe, he can introduce the program. Then, let me speak a little bit about the, IPNet, because a lot of you might not have joined, the program, or maybe joining the webinar for the first time. So IPNet is become a very vital platform for insolvency professionals across India, bringing together IPs under one roof to cater to their comprehensive professional needs and expectations. So basically, IPs have basically three requirements. Number one, expanding their knowledge base. Number two, receiving timely support in clarifying queries related to the insolvency and bankruptcy code. And number three, having a dedicated platform to represent their concerns and find practical solutions. So IPNet has proven to be an exceptionally, it has been able to be an exceptional platform to address all the concerns of IPs at a very, very short duration of time. Some of the standout features of IPNet include regular knowledge sharing, discussions within the dedicated study groups, and thought-provoking webinars on the pressing issues faced by the insolvency professionals. Each IPNet is provided with a personalized login ID, granting access to the wealth of resources, making IPNet a comprehensive one-stop hub for all the professional needs. I am confident that most of the IPs attending today are already proud members of the IPNet. However, if any one of you have not still enrolled as a member of the IPNet, I would sincerely, urge and request those members who have not enrolled to join the IPNet. It is completely free of cost, free of charge. So I would urge all the IPs who have not become the members to become a member of the IPNet. So with this welcome address, Namrata, we can, request Dr. Makhija to maybe, speak a little bit about the IPNet.
Yes, sir, we can always ask Dr. Makhija, but sir, do we also show the video? Or
yeah, please. after the video.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
With this, I request Dr. Ashif Makhija, sir, the president of IPNet, to kindly give us the overview on the IPNet.
Okay, thank you, Namrata, and thank you, Vikramji. I think, first of all, friends, a very warm welcome to each one of you to this next edition or the webinar by IPNet. Friends, as you are aware, before I say something else, friends, can I request everyone to open their videos? We would like to interact. I think after me, Pooja Bhari will also be speaking to us. I think let's interact. If we see all smiling faces, the program becomes more interesting, isn't it? So now we can see all our friends and fraternity members. Thank you. Friends, if you are not a member of IPNet so far, I would urge you to become, as Vikramji also mentioned. We will post that link in a little while in the chat box. You can click that link and you can become a member. It's just a 2-minute job. The question that has been asked, you see, many a times to me is why to create IPNet? Friends, the idea was very simple, and we are going to be 1 month old. We'll be celebrating our first 1 month old anniversary tomorrow only. So we were that program of inauguration was done on 7th September. So 6th October, which is tomorrow, we are going to celebrate our 1 month anniversary. The idea was that, look, there is no unified voice for the insolvency professional. We are facing a lot of challenges. Typically, we all know, as far as the fees is concerned, for in part 3, he says, what is my fee? How do I recover my fees? There are a lot of issues. Besides this, there are a number of issues where the challenges are there. The regulators have their own limitations. They are working within those regulations, within their own parameters. The ministry also has got their own limitations. We need to really work with them, and we need to also work with the IPs. So the idea is that let us understand each other. Let us take the voice of the IPs to these authorities. And friends, mark my words, we are in the process of making representations now. We have collected a lot of data. We have collected a lot of information. We have collected a lot of points which are bothering the insolvency professionals, and particularly also relating to the future of IBC, which many of us have been talking about. So all these questions will always be remaining. Number 2, why IPNet? The idea was hand-holding. Like assuming Mr. Shankar Panikar, Mr. Vikram Kumar, or Mr. Rajiv Agarwal, Mr. Sai Ramesh, whosoever it is, if they have conducted some of the assignments, I think they have got experience beyond, with them. Isn't it, Pooja Bahari? Now, knowledge has to be converted into experience. Now, experience, my dear friends, also gets converted into wisdom, isn't it? So, from the journey from knowledge to wisdom is a little longer. I mean, you can't get a wisdom in one day. And typically, you also don't get wisdom when your hairs go gray. No, that's not the thing. The thing is when you start doing things. So what we are trying to do is, like youngsters, like I can see Dileshwar is also there. He looks very young. So supposing he gets an assignment, he wants an assistance. Can he approach any one of us? The answer is yes. Can he look at someone? Can he go to some website where the experiences have been shared? IPNet is there. So friends, there are 2, 3 requests which I would like to make because I don't want to take too much of time. I don't want to stand between today's wonderful speaker and the very interesting subject and all of you as audiences. Of course, you will also be participating and asking questions. 1 or 2, 3 things I just want to mention very quickly. Number one, friends, we have created a website, explore it. If you have an experience, share it. There is a link there, share your experiences. It just takes, my dear friends, mark my words, it will take only 3 minutes to write down your experience. Share it with your fraternity. I think many of us have already done it, but I want it to be a continuous process. 2, we have created study groups. And study groups, mark my words once again, friends, they have been working fantastically well. I mean, it's not like a webinar of 100 people, but a very cohesive group of, say, 20 people, 30 people, 10 persons, whosoever is attending, we are discussing individual issues there. We are trying to bring out in the form of writing also FAQs. In fact, Pooja also did that. I also did it on personal insolvency because I'm heading that group. Interesting questions are coming. Interesting challenges, problems are coming. And interesting challenges naturally will have answers to that, interesting answers. So we are trying to establish a model where we can help. It's not only about webinars only. Webinars are being conducted by a lot of other organizations also. But the point is, our webinars are also focusing on absolute high quality kind of a thing. So we are trying to bring one of the best speakers in India and also interacting with them so that the answers to your questions can come. So friends, my request to you is very humble request. A, become an IPNet member if you are not. If you already become, please explore website, please join study groups, please join WhatsApp group, and also share your experiences. And if you have any question also, there is a tab which you will find. You see, do you have any question? Put that question. You will get a response and I can share it with you within 48 hours by our expert committee. What else do you want, friends? Isn't it? I don't want to speak anything more than this. So welcome once again. Welcome to this wonderful webinar. I can see a lot of my friends attending. It's a very, very good attendance and large attendance. Please continue this. Every week, my dear friends, there will be a program. And this IPNet is divided into 4 regions and one region conducts for the program for in 1 week. So it is by circulation, by rotation. And this time, this week, I think Vikram Kumar has taken the lead as Regional Director North, and they have been organizing this program. And next week, you will find Ravinder Chaturvedi in action. Of course, I believe Namrata will again be there. All right. So over to you, Namrata. Thank you so much, friends. Let's enjoy this webinar. Let's participate. Let's get some knowledge. Thank you, friends. Thank you.
Thank you so much, sir. This has really got the whole seminar in a good mood, and let's just come to the lead speaker for the day. I'd request IP Sandeep Chitkara to kindly introduce our lead speaker for the day. Sandeep, sir, you'll have to unmute yourself.
Yes, this is now unmuted. So good evening, everyone. So I'm a privileged member of IPNet. So as of now, we are privileged to have with us Pooja Bari. She is a prominent insolvency professional in India. So being a third woman to qualify in this field and handling cases under IBC since 2017. So she is a gold medalist and the alumna of Sri Ram College of Commerce which is also known as, in short, also known as SRCC. She has overseen 10 IBC cases as of now, with 4 resolution plans under her belt, approved during the COVID-19 period. She's also one of the prominent member of, as I said, she's also the prominent member of IPNet North Group. Currently, she is working on reviving United News of India. So Pooja has contributed to landmark legal precedents in insolvency law and is a recognized speaker and faculty member for institutions like IBBI and law universities. I welcome her.
Thank you very much, sir. Thank you for your kind words. And I'll just like to, before I begin the session, let me just share the screen. Just give me a second, please. I hope you can see the presentation online. Is it visible?
Yes, it is visible.
Yes, we can see.
Right, sir. Right, sir. So thank you very much, everyone. And I am looking forward to this particular session because it is one session which is very much, you could say, close to my heart also, because I have had the, the privilege of getting a lot of various landmark jurisprudence in avoidance transactions. And I hope to continue to make certain more jurisprudence. But when you make jurisprudence, you do realize the kind of challenges and issues as an IP which we face when we are actually talking about avoidance transactions. Now, before I go ahead to what are the challenges and what are the issues, there are various issues which are there. First 10 minutes, I'll just like to recap for everyone that basically what are avoidance transactions, why are they important for from the RP perspective, why are they important from a liquidator perspective, how is it that we why is it that it becomes very important for us to understand avoidance as much as maybe we understand the resolution and the liquidation processes, because this is a very integral part of the entire IBC. But in these 7 to 8 years, various issues have arisen. So I will be discussing each and every one of them, and most of them have arisen because of certain jurisprudence also. So let us just start the session. So beginning, let's say first 7 minutes, I'll just try and cover what are avoidance. As you know, avoidance are the preferential transactions, undervalued, extortionate credit transactions, defrauding transactions, and fraudulent transactions. So basically, if there is a director who could be held liable for fraudulent or wrongful trading, or for preferential transactions, or for the extortionate credit transactions. So this is the basis of the transactions. As an RP, there are certain regulations, certain sections due to which it becomes extremely important for us to understand that why any decision about an avoidance transaction has to be taken in a time-bound manner. Now, the first thing is, of course, by the 75th day, we are supposed, as an RP, we're supposed to form an opinion whether there have been any avoidance transactions, whether the corporate debtor has been subject to any preferential transaction, undervalued, extortionate credit, or a fraudulent transaction. Again, once he makes the opinion, he has to make a determination, and that is by the 115th day. And where the RP has made such a determination, then he has to apply to the adjudicating authority before the 130th day. Earlier, this was 135th. Now that has also been reduced to 130th. So, and also the RP has to forward a copy of this application also to the prospective resolution applicant to enable him to consider the same while submitting a resolution plan. So this is something new which has been added from an RP perspective, from a resolution point perspective. So this application ought to have completed by the time you're issuing your RFRP. So that this is the reason this has been added, that 130 days it has been made that you need to file an application before the NCLT by the 130th day. Another regulation, which is 39(2), where it is specifically written that the RP will submit to the COC all resolution plans which comply with the requirements of the code, along with the details of the avoidance application. So when you are placing any plan, if you, as a resolution professional, whenever you're placing any plan before the COC for their consideration, you also have to give them the details of the avoidance, whether if there is any preferential, undervalued, extortionate credit, or any fraudulent transaction, and of course, if any orders have been passed till then. This is when, from the perspective of an RP, from the as from the liquidation point of view, one of the powers and the duties of the liquidator is to investigate and to determine if there are any undervalued or preferential transactions. This is a particular section 35L. And also, as per section 36F, we need to understand that the liquidation estate will include even those assets or the value recovered through proceedings of avoidance transactions. Further, now the regulation 38.2 basically of CIRP says now even a resolution plan has to compulsorily provide the manner in which the proceedings in respect of avoidance transactions will be pursued after approval of the resolution plan, and the manner in which these proceedings will be distributed. And further, a new amendment which has been again made in liquidation regulations is that how the avoidance will be treated. So the treatment of avoidance transactions, that on the advice of the stakeholders consultation committee, the manner in which the avoidance proceedings in respect of avoidance transactions will be pursued after dissolution or closure of the liquidation process, and the manner in which these proceeds will be distributed. This again is a part of now the liquidation. So before you're filing an application for dissolution, you have to have the advice of the SCC that how these proceedings will be pursued and how the proceedings will be distributed. So basically, as an RP, as a liquidator, there are various sections, there are various regulations due to which avoidance transactions become a very, very important aspect in the entire IBC process. And broadly, the transactions could be avoidance, could be if there is any transfer made for the benefit of a creditor or a surety or a guarantor to put the recipient in a beneficial position in relation to other creditors, or it could be gifts or transfers of property at a value significantly lower than the consideration which was paid by the corporate debtor, or if any transaction has been deliberately intended to put the assets of an entity beyond reach or to adversely affect the interest to any claim, and also if there is any financial or operating debt on exorbitant terms. All these are a broad description of the transactions which are to be avoided. Now, before we actually come back to the issue, go ahead to the issues, 4 transactions, which are the major transactions, I'll just make you go through them very quickly. Firstly is, of course, preferential transactions, where the RP is of the opinion that the corporate debtor has at a relevant time given up preference. Now, this preference could be payment or a setup of debts which are not yet due. It could be a preference of granting of security interest to secure existing unsecured debtors. It could be an unusual method of payment. It could be a payment of debts in response to extreme pressure. So all these are preferential transactions when there is a transfer of a property of an interest of the corporate debtor for the benefit of a creditor, of a surety, of a guarantor, on account of antecedent financial debt, and that transfer has the effect of putting that creditor or that surety in a beneficial position than it would be in the event of distribution as per section 53. So this is primarily what is preferential transactions. Undervalued transaction is what is not an arm's length transaction. What it implies unequal exchange, or it could be a gift of significantly less value. So if the RP or the liquidator feels that there is a transaction which has been made, of course, in the preceding 1 year or within 2 years to a related party, if it can be considered if it's a gift to a person, or the transaction where it was transfer of one or more assets of the corporate debtor for a consideration, the value of which is significantly less than the value of the consideration provided by the corporate debtor. And if it has not taken place in the ordinary course, that's an undervalued transaction. So, the NCLT could order to return that property or release or discharge or reverse such security interests. And of course, you can even require the person to pay back these sums, the benefit which has been received by that person. Transaction defrauding creditors is firstly, if it is can everyone please mute themselves? I request all the others to mute themselves, please. So a transaction, if it is an undervalued transaction, but it has been deliberately entered into
Well,
by the corporate
yes,
debtor, and particularly
okay.
if they had been entered for keeping the assets of the corporate debtor beyond the reach of any person to adversely affect the interests of that person, then that could be a transaction defrauding creditors, and the NCLT can restore the position and to protect the interests of the persons who are the victims of these transactions. Finally, there is something called an extortionate credit transaction, which is where if there is a term of transaction which requires exorbitant payments to be made by the corporate debtor, and it is within the past 2 years, then the NCLT can restore the position as it existed prior to the transaction. It can modify the terms of the transaction. It can set aside the whole or part of the debt which has been created. So this is the summary and the comparative table of what is of the preferential, undervalued, extortionate credit and transaction defrauded creditors. Besides this, even in avoidance, there is the section 65, which actually comes in, and section 66. So as per section 65, if there are with fraudulent or malicious intention or initiation of proceedings has happened, if it is perceived that the applicant's motivation for putting the process was for a purpose other than a resolution, then section 65 comes in. And section 66 is one of the most important sections because there is no look back period. In preferential transactions, in extortionate credit transactions, there is a look back period. In the other transactions, but in section 66, there is not a look back period. So if, as per section 66, if any business of the corporate debtor has been carried with the intent to defraud the creditors, then any person who was knowingly party to such carrying on the business will be liable to make the contributions to the assets of the corporate debtor. And also, if the person knew or ought to have known that there was no reasonable prospect of avoiding the commencement, and the director did not exercise due diligence in minimizing the potential loss, then the NCLT may direct the director to make contribution of the assets of the corporate debtor. So this was a synopsis of what are avoidance transactions and why, as an RP, as a liquidator, it becomes extremely important for us to understand why they are important in the entire process. Now, let us come to the challenges, now, which is our main session for the day, that as an RP, as a liquidator, what are the kind of challenges which are faced? So I will firstly, I have two very important cases of mine, which I will be discussing, which actually give rise to what are the issues in avoidance. And then we will be discussing various other issues also and various other judgments which have put some kind of question mark that how actually will the avoidances be finally adjudicated, because the issue is the time-bound process we are supposed to follow in IBC. Unfortunately, because of various avoidance and PUFE transactions, dissolutions are not happening. So one issue is in one of my matters was where the dissolution could not be allowed because pendency of an investigation. So this, and the NCLT adjudicating authority answered a question whether the pendency of any investigation creates a bar for passing an order of dissolution of a company. Now, in this particular matter, I had filed an application for avoidance. It got adjudicated. It ended in order by the NCLT that the affairs of the corporate debtor should be investigated by the Ministry of Corporate Affairs. So when actually after, as a liquidator, when I finally sold off the assets within a period of 4-5 months, distributed all of them, when I actually filed the application for dissolution, the court held that dissolution will put an end to the legal existence of the company. It will become non-existent. And the liquidator will also not be able to represent this non-existent corporate debtor before any investigating forum. And of course, if any recovery is affected or an asset is recovered through the investigation, the same needs to be vested in the corporate debtor. So they held that the pendency of any investigation would create a bar on passing an order of the dissolution. So they say, yes, as a liquidator, it is our duty to mandatorily liquidate within a particular period of 1 year. It is mandatory to make an application for dissolution, but because of an investigation which is ordered by the NCLAT, again in this particular case, creates a possibility of infusion of more assets, and there is nothing stipulated in the regulations that binds the adjudicating authority to actually order for the liquidation, dissolutions. They said yes, The liquidator has to make the application, but nothing binds the NCLT to actually order for dissolution. So they said that to facilitate completion of investigation for maximization of assets, for smooth distribution of proceeds from this investigation, the judicial proprietary demands that the corporate debtor should not be dissolved at this stage when an investigation is ordered by the Honorable NCLAT is pending. So we are of the view that the pendency of an investigation creates a bar on ordering dissolution of the corporate debtor. So when there is no dissolution which happens, so this is a problem which has arisen from the application for avoidance only which I had filed. Basically, as per section 66, the orders which ought to have been passed should actually have been, as you can see, as on your screen, section 66 says that these people should be liable to make contribution to the assets of the corporate debtor, which was one of my prayers which had when I had filed. But because of the fact that because of a pending investigation, dissolution can't happen. So that particular matter is right now today continuing till 5 years. So today I made the 24th progress report in that particular matter. So the fact of the matter is this is one issue in avoidance, that what happens when dissolution cannot happen. Yes, the IBBI did take up this particular issue and they made the change. As you can see, the change which I had discussed earlier, that they made a change that how will the treatment of avoidance of transactions be done, that firstly resolution plan will provide how these proceedings will be carried on, and in case of liquidation, on the advice of the SCC, how these proceedings will be carried on, and the manner in which these proceedings, how will be distributed, the proceeds from these proceedings, have also this regulation has been added in liquidation. But unfortunately, if some avoidance does end up in an investigation, then then it will not be possible to dissolve that corporate debtor. So we need to have some kind of clarity in the court that when investigations take many years, especially with reference to fraud and fraudulent transactions, then is the liquidator to continue? What fees is to be charged by the liquidator? Who is going to bear the expenses, especially the legal costs, especially if they've not been approved by the COC or the SCC? And we feel that, I think that's an advice which I had given earlier also to the MCA, that these avoidance matters maybe could be assigned to some outside specialized agency that could have been for the benefit of, for the larger people, because we as an RP and liquidator have very limited, bandwidth to continue when there is continuing investigations. So if these matters could be assigned to an outside specialized agency, so that is one advice which we can, put forward further on. Also, there are cases where the RP would have filed an application, and but the NCLT has not considered that application during the tenure of the CIRP, and then the IRP-RP moves on. So sometimes, yes, now it has become, compulsory to inform that who is going to carry on the particular avoidance application. But also there are still questions at what fees, or if any fees, and if we're charging any fees will be perceived incorrectly. And what if the COC or the SCC does not confirm any fees? That is also a possibility. As an RP or a liquidator, we may say that, yes, we will carry on, because that is what is happening when an NRR is being assigned, that what fees is it will be paid to the liquidator or to the RP to continue these transactions. But clarity is needed that whether charging of any fees is perceived correctly or not. In one of my matters, I got the orders, which I'll be discussing that matter much after the plan got approved. And in this, it was mentioned that how the proceedings will be distributed, it was mentioned, but who will pursue was not mentioned. But now the court wrote one line to me that I am to pursue. So because of that, it's been about 2 years I've been pursuing that matter. But could I charge fees? Can't I charge fees? It is not mentioned. So if a clarity can come in that is one challenge, which is also there in avoidance transactions. Also, a mechanism needs to be there where these applications can properly be pursued, because what happens, even if a resolution plan gets approved, and I've had cases where the NCLT has taken affidavits from the resolution applicants that they will properly pursue, But when you look at it, there are certain RAs who would not be interested in pursuing. In a lot of plans, they have mentioned that we are not interested in pursuing an avoidance application. Then what? Then what happens to the section or the duty which has actually been given to the RP to ensure that you are filing it properly, but whether it is actually pursued later on also it becomes extremely important. So yes, I mean, it is one advice that if there is our SFIO, CBI, ED actions are ongoing, then there could be a particular respective agency who should actually carry on these avoidance. That is something which can be discussed further on. We need to discuss with IBBI, with the MCA, how that can happen. Then there is another issue which is there is, of course, which I've discussed. One is where the dissolution does not happen. Another issue which is there is the obligation to follow up with the adjudicating authority. There are times where the term of the RP is expired, and and then there were certain judgments which had come, especially which was Venus recruiters. Of course, now that has been set aside in various other matters, especially in my matters also. But there are cases that issues relating, if they have not been properly resolved, who would be responsible for taking the process properly forward? The onus of the implementation of the order of the adjudicating authority is also one very important question. Now, there was this case in which the onus came on me because the application got allowed, but then in all the appeals which were filed against the avoidance were, so and so company versus Pooja Bari. So when you become the one who's the respondent, and when you are the erstwhile RP and you are the erstwhile monitoring professional, till how long can you continue with the onus of the implementation? I am doing it, but would all the RPs do? Would they have the time to do? Would everyone have the bandwidth to do it? That is also a grave question which needs to be answered, because when the appeals are filed and when you are no more there, and then but it is when in fact the appeals went up to the Supreme Court, so all the appeals were versus Pooja Bari. So yes, I did fight them and I did win them, but it is not necessary that every RP would have the time or the expertise to actually fight. So the onus for the implementation, even if the avoidance order is passed by the NCLT, the order of the adjudicating authority, it is the responsibility, it rests with the RP during the CIRP process. But when the term of the RP is over on resolution, the issues around this avoidance have not been properly resolved, then who would be the one who would be responsible? That is one issue. Then beneficiary of gains from the order of the NCLT. Now, there are certain cases where it is mentioned that the corporate debtor will get the gains back, certain where it will be given by as per section 53 of the code, certain where it is written that particular financial creditors will get the gains. Unfortunately, the jurisprudence is such that there are various contradictory judgments. There are certain judgments which have said that even when the gains are given by, they should not be given back to the corporate debtor. They should be distributed as per section 53, which seems the correct course of action. But some clarity, if that could come, that is also required, because once the CIRP has concluded, there could be instances of recovery, and these questions around the fate of these recovered funds. Yes, it is mentioned that how it will be, distributed, but there are various cases which are older cases where such questions have not been answered, because what is pending right now in the courts and the avoidances are those cases of 2018, 2019, 2020, where these amendments had not come in, that who is going to be the beneficiary of these proceeds and who is going to pursue these transactions. So a lot of the avoidances which are right now pending in the NCLT are the earlier matters where this clarity has not come. So yes, the monitoring, and again, when there are appeals post completion, who would take on the responsibility for pursuing the appeals, who will be responsible for pursuing the legal matters? This is again a question of avoidance which has arisen. And the expenses. Now, yes, if the money has actually comes in and they give back the as per the avoidance application, if the money actually comes in, then that expenses are could be, are borne usually by, and usually the what's given in the orders is that you reduce the expenses and the other the balance amount gets distributed. But there are cases where the money may not come in. which may go on till the NCLAT, which may go on to the Supreme Court. So yes, the code provides for meeting the cost of the CIRP, the liquidation, but once the processes are over and the sources of funds to get back, then who is going to pursue the legal options? And they could be costly. And when a corporate which survives as a going concern, the situation is different. But where it has gone into liquidation, the SCC members are not ready to fund, then what happens? In fact, there are so many cases where the liquidation fees has also not been approved by the SCC, COC, not being paid when there are no assets. So when there are those no assets, then who is actually going to bear the cost of the avoidance post the liquidation remains also a question. So yes, there are some questions about the adequacy of the current framework in dealing with fraudulent cases. That is something which is important. So the fate of the POFE transactions, how when it is over properly needs to be addressed. I mean, I have a feeling that, you know, a NARCL like institution is needed where, you know, other authorities, they are the ones who can actually pursue these applications if it is, you know, something, if that can come about. Then again, another matter I'd like to discuss with you, which went up till the Supreme Court, but now the issues which are faced are very different. I mean, this was a matter in which I'd filed an application for avoidance. Orders were passed in March 22 regarding avoidance. I mean, my plan got approved in Jan 21, got implemented in 2 months by March 21. Orders of avoidance came after 1 year. So orders were passed in March 22 and the preferential transactions were allowed by the NCLT. So they partly allowed it. They directed the parties to refund that particular amount in accordance with the resolution plan. Now, as per the order, there were certain respondents. They were directed to take steps to give the amount. And I was directed as an erstwhile RP, erstwhile monitoring professional, to take steps to distribute the amounts among those financial creditors who are entitled to get it and file a report with the NCLT, compliance report thereafter. And if they failed to deposit the amount, then the same shall be recovered in accordance with the provisions of law. Now, this was just one line. I mean, one line, I'm directed to take steps to distribute the amounts among the financial creditors and then file a report in the NCLT. And then if they don't pay, then it is my duty to recover in accordance with the provisions of law. Now, this one line for the past, since 2022 till now, I am still fighting. I'm still fighting. I fought up till the Supreme Court, got the money, made landmark jurisprudence in it. But now there are new issues with reference to, in that avoidance, it has gone now to the PG level. So I'll just discuss this matter, because with this matter, what issues are faced will actually be, brought about. We'll be able to understand. I mean, this matter went up to the NCLAT. The NCLAT, I had 3 appeals, like I said, filed against me. I fought with the appeals along with my lawyer. And finally, they were asked to refund the amount of preferential transactions, and these 3 appeals were dismissed in April 23. So when you see 22 was the order, April 22, April 23, the appeals got dismissed. And it was a very, very important judgment with reference to avoidance. They clarified the scope and meaning of preferential transactions. They clarified the scope of the exception, which is what is ordinary course of financial affairs. The question of intent or motive was also it was also addressed that is not relevant when a transaction is a preferential transaction. It was also, NCLAT also held that any transaction under this notice, demand, threat will also not lose its character of preferential transaction merely because of these reasons. Detailed analysis was given of the ordinary course of business, what is ordinary course of financial affairs, how intent of the corporate debtor is not relevant, even if the act is voluntary or not, has no relevance in deciding whether a transaction is preferential or not. Then in the NCLAT, they even, another issue which had come up with in one of the orders was composite application. If a composite application is filed by RP, all those applications were getting dismissed. So luckily that answer had come in this particular order also, that if the allegations and avoidance were separately made in different heads, then filing of a composite application does not lead to any infirmity in the application and ought not to have been rejected. So they said that even the judgment of Venus recruiters had been decided overruled by the division bench. And finally, the ingredients, when they are proven of a preferential transaction, there is no need to prove any fraudulent intent. So they went into detail. I mean, NCLAT decided that they will give a very comprehensive order regarding preferential transactions. They decided on a deeming fiction. They gave that when a deeming fiction comes into play on fulfillment of the requirements, and even the transactions which only fall as an exception can be taken out, the else all will be a deeming fiction. So even taking financial assistance from non-related parties, they cannot be held in ordinary course of business. I mean, detailed analysis had been done that what the expression of financial affairs of the corporate debtor cannot be given an extended meaning, and hence, and all financial transactions cannot be covered under financial. They wanted to cover it under the exceptions. So they also gave to the submissions of the composite applications that if the ingredients are different and the RP is only expected to keep such requirements of law while making an application. So this was a complete order. I got back a majority of the amount there were about four of them, four respondents paid back the amount. Some took time, some took extensions from the NCLAT, and finally I've distributed that amount. And these orders were even upheld by the Supreme Court. They went to the Supreme Court. Supreme Court upheld the NCLT and the NCLAT order, and they said we are not inclined to entertain these appeals, and accordingly the appeals were dismissed. So actually finality reached with reference to law with respect to preferential transactions in these matters, and all appeals against the NCLT were dismissed in April 23 by NCLAT. Further appeals were dismissed by the Supreme Court. Now, many issues had been addressed in that judgment of the preferential transactions, but then now new issues have come up. So yes, these appeals were addressed, but now the issue which I am facing right now as the erstwhile RP and the erstwhile monitoring professional is firstly these questions which everyone RP will need to understand: that what if the contribution is still not made despite Supreme Court orders? This happened in one of them. What recourse is available to the RP or the liquidator? What powers does the erstwhile RP have? And if the RP and the liquidator files a contempt, which I have, because was supposed to by law, given that one line that I am supposed to take further action as per law. So I did file a contempt. Does the law and the code even permit? Does it even support him? So these are questions that we are doing our duty as an RP, as a liquidator. If suppose there's an avoidance upheld by NCLAT, upheld by Supreme Court, but still if the money is not paid, then what? I mean, yes, out of 7, 4 paid. The related parties directors did not pay. I filed a contempt, but then the persons who are to contribute and then they have now filed PG, personal guarantee. Now that's another issue. See, when you close certain issues, like I said, it's not that some issues have not been resolved. They have. We've had good judgments in avoidance. I've been a party to various good judgments, but now there are new issues because when the law changes, new gray areas come up. So now the gray area is there. If now the directors who have been asked to contribute the funds, and they file an application for personal guarantee, is interim moratorium firstly applicable? Are these amounts excluded debt? And can a repayment plan be given for that amount which has been adjudicated as an avoidance? So in personal insolvencies, yes, everyone knows there are various gray areas which need to be plugged. The PGs are siphoning off a lot of personal assets. There are further no provisions which can be utilized by the RP. And in many cases, PGs have already transferred the assets outside India. No provision to make those assets a part of the repayment plan. And no way that an RP can get data regarding these assets, especially if there are cross-border assets. Now, when you talk about PG to CD, there are cases when investigations are pending and a PG case results in bankruptcy order. then also your investigation report results in a confirmation of, suppose in fraud, the PG would already have been declared bankrupt. Now, in my first matter, which I was discussing, where the court did not order dissolution because of a pending MC investigation. The MC investigation is ongoing. I think it is almost over. Now, even if that investigation results in saying that, yes, they committed fraud, and in the meantime, in an application for PG is filed and bankruptcy is filed, and that particular person becomes bankrupt. So then what would be the point of me as an liquidator pursuing that for 5 years before the Ministry of Corporate Affairs, before the MCA, or any other investigating forum? Because even where the investigations are pending and the PG cases result in a bankruptcy order, they'll say, I'm bankrupt. I'm already bankrupt. Even if you're saying, yes, I've done the siphoning, even I've done the fraud. And even if that investigation report results in confirmation of fraud or siphoning, and they say that, yes, there is a possibility of infusion of more assets in the corporate debtor, but as the PG would already have been declared bankrupt, so then the bankruptcy order in that case would result in misuse of the provisions of the IBC, where investigations of fraud are ongoing. So a clarification is required for this also. Then, coming back again to PGs, what will happen to pending investigations ordered by courts before MCA SFIO when interim moratorium is imposed on an application filed for personal insolvency under Section 94 of the Code? So there should be a clarity. Yes, there was a judgment in 2021, which is of the High Court Calcutta judgment, which said that to stay willful defaulter proceedings, criminal proceedings, or quasi-criminal proceedings under any moratorium under Section 96 would defeat the object and purpose of the Part 3 of the IBC, and the stay of such collateral proceedings would also result in putting a premium on the impropriety and illegality for which these proceedings are ongoing. So yes, there are issues with reference to PG to CD, and the interplay between avoidance and personal insolvency is very much so. Because is the money which is ordered to be paid by the NCLT, NCLAT, Supreme Court under an avoidance transaction, if it becomes is it a part of excluded debt? Now, I am fighting this particular matter. Again, like I said, because I have been told to, in that one line, to take, action as per law. Again, I have submitted to the NCLT that if a PG petition is admitted, it would set a wrong precedence, as parties would claim interim moratorium by virtue of filing this petition under Section 3 of the Code. Also, it would be in the interest of the IBC to clarify whether any amount which has been adjudicated in an avoidance, which is filed by an RP liquidator, firstly, can it be construed as an excluded debt? Whether that amount can become a part of the repayment plan by the personal guarantors and consequently be reduced, and whether a personal guarantor can derive the benefit of interim moratorium. Now, these questions are the new gray areas. There were earlier gray areas. Now there are new gray areas once this law has of avoidance and mean a lot of cases being settled. So yes, the code and the regulations should clarify the same, because it would be for the benefit of all, including us IPs, for us to be able to understand where are we going, till when are we fighting, and till how long are we supposed to fight. Another very important aspect when we are talking about avoidance is now, like I said, we can now assign. We can do assignment of not readily realizable assets. Now, what is an NRRA? One of them is an asset which is, asset underlying an avoidance proceedings is also not readily realizable assets. As under liquidation, a liquidator can assign or transfer a not readily realizable asset in consultation with the SEC for a consideration to any person who's eligible to give a resolution plan. Now, this is what the regulation says. It came in 13 November 2020, Regulation 37A. So now everyone thought, yes, the liquidations are not finishing. So let us use the option of NRRA, let us assign, and we will just minutize that this is the person who will be pursuing the avoidance further on. Then came, of course, there are other issues in NRRAs about the what will happen to ongoing investigations, who will assist the department. Those are separate issues, I mean, not to be discussed here. But then came the order of Ritu Tandon versus Rain Automotive, which held that the NCLT cannot adjudicate an avoidance application which is pursued by a third party to whom a debt was assigned under section 43, 45, 50, and 66. So the bench said that the NCLT has no jurisdiction to adjudicate an avoidance or a PUFI transaction which is pursued by a third party or an assignee. They say that in terms of section 65, the NCLT has no jurisdiction to adjudicate an avoidance pursued by a third party, which will become a dispute between two third parties. One is the assignee and the respondents of the avoidance applications, neither of whom represents the corporate debtor, which will be dehors the insolvency proceedings of the corporate debtor, and they decline to substitute the assignee in place of the liquidator. Now, this order came. Now, because of this order also, I mean, there was one case of mine which I was thinking of assigning in, let's say, 2022. Now it's been 2024. Now I am thinking of assigning it again. So yes, but the brief facts in this particular matter was a liquidation was initiated, PUFE was filed. As per Regulation 37A, the applications were put to actionable claims, the bids were invited, and for 50,000 rupees, they were assigned as an NRRA. Then the assignee approached the NCLT to substitute his name in these applications. Now, there were 2 points which the NCLT held. Point number 1 was, when can the liquidator assign an NRRA, which is a PUFE application, which is an avoidance application? So they said that the NRRA under Regulation 37A describes that any asset included in a liquidation estate can be sold as an NRRA and their value recovered through proceedings. Further, they said there is ambiguity in determining the actual value for the PUFE prior to adjudicating of the same. So they said the basic objective of an avoidance is to transfer due benefit back to the creditors. In this instant case, the avoidance application of 26 crores has been assigned for 50,000. Thus, it will enrich the assignee and not the creditors. So the issue 1 which they discussed was, at what stage can the NRRA be assigned? Is it before adjudication or after adjudication for avoidance? So they discussed Regulation 37A. They discussed that if there is no adjudication, there will be arbitrariness in valuation of the claims, and the avoidance will enhance the pool of the corporate debtor. And they said that the intent behind avoidance is not recovery, but maximization of assets. So their decision was that the NCLT, the liquidator, cannot assign NRRAs arising from avoidance before adjudication of the applications and determination, and the debt can be assigned only after crystallization of the amount. Second point was, can an NCLT adjudicate this application pursued by an assignee? So they said that section 43, 45, 47, 50, 60 expressly mention RP or liquidator as the person preferring the application. Now, the application filed by a third party cannot be adjudicated by the NCLT. So they said only after crystallization of the application, debt can be ascertained and hence assigned. Now, the issue was, yes, it is a very strict interpretation, but it also bears some merit because somehow it could, but it did frustrate the already, you could say, skewed liquidation processes. And if the PUFE can only be pursued by an RP liquidator, then where does that regulation comes in, where it says that who will pursue when you are filing an application for dissolution, who will pursue, you will monetize it properly. So that becomes irrelevant. So this was a very important order which came in. They said, the NCLT said they do not have the jurisdiction to adjudicate an avoidance which is pursued by an assignee instead of the RP or the liquidator. And the avoidance can only be filed by the RP liquidator. There is no provision for assignee to pursue this application. After assignment, disputes become between assignee and respondent instead of CD and respondent. So this application will cease to be an issue arising from the CIRP or the liquidation of the corporate debtor. And the NCLT that can admit only applications by or against the corporate debtor. So they said avoidance applications by assignee will not follow within the purview of that particular section. So yes, Now, the crux of this particular case was that the NCLT does not have jurisdiction to adjudicate an avoidance pursued by a third party assignee to whom debt was assigned. And if the debt is assigned, then the application cannot be pursued by the corporate debtor if it is assigned to a third party. So they said that basically, the questions arose that now, then NRRAs for about 2 years were not getting, they were not getting assigned. Now, recently, in one of my matters, now the court in open court asked me, why are you not using NRRAs? So now we've started pursuing it, but the order still stands. That order particularly still stands. So some other bench may pass orders. Some benches are passing orders. It's not that the orders are not there, but then yes, clarity is needed. The reason I'm discussing all these orders is because we need some clarity. These are the issues which are there when we're talking about avoidance. And yes, the most important issue is the number of years. Now, the number of NCLT benches, of course, will be increased as soon as possible. In fact, avoidance applications which have been filed, most of the applications for avoidance take years. And as the matters do not reach, because there is a long cause list, and even if they do reach, they are the ones which are of the least priority. So because they are of the least priority, they take years. And unfortunately, there are contradictory judgments regarding interpretation of the law, which are being used and misused by the parties. So these are the primary issues which are there. Some other concerns, some other questions over the past 8 years, where the liquidators have been asking about avoidance, are some very important questions. Basically, what parameters we can use to form an opinion and then to determine each of the 4 kinds of avoidance transactions. What process should be followed to form an opinion if a corporate debtor has been subject to an avoidance. Some questions which are there is, these questions keep us thinking that should every CIRP examine and investigate if the corporate debtor has been subject to an avoidance transaction, whether it is necessary to conduct a transaction audit or a forensic audit, who can help the IP in detection of the avoidance transactions? That is something, these are questions which were there. A lot of them have been answered. In the past few years, a lot of these questions have been answered, but many do remain. Basically, firstly, another question was, can the RP liquidator himself be the forensic auditor? Is it necessary to consult the COC or the promoter to order an audit? Whether the approval of the COC is required for expenses to be incurred? Whether when the CD has resources constraints, should audit be avoided? In one of my matters, the COC did not approve an audit, but it was required. And I did get it done, and the court actually ordered the COC to ensure that that becomes a part of CIRP costs. So every case is different. Every audit finding is different. There is a huge level of non-cooperation which is there, due to which it does arise that the applications for avoidance take a longer period of time. Many times it happens when you actually file the application, note information is provided to you, but once it is in the court, the other side would give hundreds of pages of documents which are there, and file it in the NCLT. So that's one constraint which I also have faced. Then there are issues with reference to when should the CIRP conclude. Of course, when an application for avoidance is passed. So many of these questions have actually been answered. Now, this is all I had to say in this 1 hour. There is a lot more if you want, I can go in detail of that particular matter, but I think let's open it up. Let's open up the questions which are there so that we are able to understand the avoidances a little better. So if, I had about an hour to speak, so I think I have taken a little more than that. So any questions which are there, let's all discuss with, let's open up your videos and let's just try and discuss. Yes, sir.
Mine is directly relevant to your past problems. I am an
Yes, sir.
RP of a large corporate debtor today
Yes, sir.
from Hyderabad.
Yes.
We have filed avoidance transactions thanks to my advisor, not my own capacity, but we have filed some very good about 1,000 crores.
Okay.
Avoidance have been filed. But my problem is very current and practical. real problem. Uh, uh, there is a likelihood of 12A.
Okay.
So if 12A happens, where do I stand? COC will not be there, SEC will not be there, and promoter will be gunning for whatever I have done these 2 years of RP.
Right.
Many things, maybe GST, taxation. Apart from all that, we have filed avoidance transaction. If a 12A happens, where do I stand? I'm really
Sir, as
putting-
I mean, everyone can, I think, chip in and give their answers, but I genuinely feel, as in the 20, it is your duty to inform the court when the 12A application is filed, that there is an avoidance which is pending. So that is also a very important part which needs, but yes, when avoidance is pending and it is not adjudicated, that person does not become, barred from even, in fact, even giving a plan. If you would go into section 29A, that's also another thing, that if an avoidance is pending and it has not been adjudicated, that person is not, or that promoter or that director is not barred as per section 29A to give a plan. So of course, but it is your duty to inform the court, and I'm sure the court will take a cognizant decision, because it is the 12A is the COC's discretion. We are 90% there is consent, it is there, you can't do anything about it. But yes, you need to inform the adjudicating authority so that they take that into consideration while they are, passing the orders as per.
Can I ask for funding? Who can
Pooja, I
ask
will
for
just
funding?
interject here. Pooja, I will
Yes,
just
sir.
interject.
Yes,
Actually,
sir.
we have Shankar Pani in Panigrahi. Shankar Panikar, sorry. He is the moderator. I think you let him moderate, because
Okay.
otherwise it becomes a little So I will request Shankar
Please.
ji to come
Please,
in.
Shankarji.
Yeah, and then I think that will be more organized. Please, thank you very
Right,
much.
right. Please, sir. Please, Shankarji.
Yeah, good evening, friends. I can really understand my friend Ramesh from HIPA, the anxiety he will be facing when it comes to avoidance transaction. So it is absolutely okay to get, seek information from one of the classic speakers in the subject. Friends, thank you so much for coming in large numbers. We will definitely, without wasting not even a second, we will quickly move to the question answer or some deliberations. Before that, look at the beauty of this code. In every way, whichever way you look into the IBC, whatever happens to a corporate debtor, there will be some reason for that. For example, in the case of a company which is going into the insolvency position, there will be some history. So there will be some wrong business call, or a willful, siphoning out of money, or be it as it may. So IBC is structured in such a way that the RP or the liquidator is supposed to go and form an opinion as to what went wrong and where did the money go. And there you get this avoidance transaction. So 43, 45, 50, 49, 50, and 66 is essentially to understand and take action as to what exactly was. On one side, a creditor has given money, another side, it's not being seen in the asset side, and it is being siphoned out, or something has happened. So this has got larger meaning, according to me, avoidance transaction, and it has got a purpose for, a clear purpose for putting up this, for enacting this section. And look at the extreme. You have a situation assets which cannot be realized. So this is something which is going to have a lot of issues, challenges. And another thing is the inability of the RP to form an opinion. I don't think any company, any insolvent company, or a company which is being referred to CIRP will have adequate information so as to form an opinion for the by the RP or the liquidator. So these are the basic challenges. I'll just quickly move to the chat box first. Now that Rameshji has bounced that idea, and it was the biggest googly ever speaker can get, that to a 12A with 90% COC, anticipating a 12A withdrawal with 90% voting, and voting to take up avoidance transaction. That
Debts
also
admitted are 10,000 crores.
absolutely. So this is the biggest googly, maybe a boomerang bowling to Madam typically had a wonderful defense, says put it to the NCLT, let us see what, and it will evolve. Thank you so much, Rameshji, for bringing up that topic. I'll quickly go to the first question, ma'am. So after that, we'll have a, interactive session. Surendra Devasani says, Buffet transactions IAS filed against the promoters and others are pending for adjudication by Honorable NCLT, and promoters have become successful bidder in e-auction. Can we accept his bid and issue sales certificate? A practical question, madam. Your views on that?
So my view is like I just discussed, Section 29A does not bar anyone. Of course, when you're selling in a liquidation, first you need to ensure that anyone who buys any asset in liquidation has to be compliant as per Section 29A. Then when you come to Section 29A, it does not bar anyone until and unless the avoidance has been adjudicated. Yes. So till the avoidance has been adjudicated, as per law, there is no bar. But my advice, of course, would be to keep IBBI informed, to ask them for their opinion. I mean, to keep yourself safe also. It's a possibility they may give a reply, they may not give a reply, but it's something which you can also ask that yes, we feel that I feel that this is Section 29A. As per my report, 29A, he is not non-compliant, he's not ineligible. But also when you are informing the NCLT again, because see, adjudicating authority has the most importance. Firstly, you need to inform the adjudicating authority that we have sold to so and so person. As per my Section 29A certificate, they are compliant. They are not ineligible, but there is an avoidance which is pending. So firstly, it is important to inform the NCLT about that, inform IBBI about that. Also, discuss it in the stakeholders consultation committee. Discuss these particular regulations, that please discuss Section 29A in its entirety, discuss the report of eligibility of that particular person who has bought the assets. Because it is, I think I remember there was this clarification in 6th of January 2020, which had come, that anyone who is ineligible in the court to give a plan would be ineligible to buy the assets in a liquidation. In fact, that had gone further to say even the COC or the SCC member cannot sell an asset to someone who's ineligible as per Section 29A. But then we come to 29A, till the avoidance is adjudicated. I mean, they can participate, but it's better to inform IBBI, better to inform the adjudicating authority, because you need to take steps to protect yourself. That would be my advice. Anyone else has their advice? I'm sure that would be.
With all respects to IBBI, my Surendra sir, and my only view is you cannot expect a reply from IBBI. Just keep a copy and approach NCLT. Getting a reply from IBBI is next to
Yes,
impossible.
sir. I have already filed. Yes,
Ah,
sir.
yeah, and
I have already filed one IA with Honorable NCLT,
that is the best.
asking to clarify whether I can take the sale certificate. Yeah.
Alternatively, what I suggest, sir, is this. We address yourselves a question. Who are we? We are the officer of court. Therefore, we are duty bound to inform the appointing authority as to this is my challenge. This is not clear. And if possible, you may put a copy. I mean, you can make IBB also as a respondent. Let them act. So what happens here is you are in a very walking on a tight rope. The moment something happens, everything will fall on you. Therefore, my strong view is you have taken a correct stand. But had I been in your position, I would have definitely kept IBBA also to bring in clarity. Because letter won't take
Yes,
us.
sir.
The next question, I hope I will take the next question. The next question is Ramesh sir, he has asked, and I'll just skip that, sir. If we get time, we'll come back to you, sir. The third question, what happens? The question is, what happens when CD has paid settlement amount within the look-back period whereby the unsecured financial creditor had filed Section 7 application and ordered in NCLT order? Madam, the
Uh,
question is very simple. What happens to CD who had paid a settlement amount by within the payback look back period, and in between FCA has filed a Section 7, and that settlement was ordered in the NCLT order? What could be the option?
No, if the settlement was from the NCLT only, so that is something by a NCLT order that ought not to have been a preferential transaction. But in the judgment which I said, which I had discussed earlier also, there is a deeming fiction that if there is any other order from any other court also. So in fact, the Anuj Jain case of the Supreme Court is a very important case which had been looked at by the NCLAT in my matter when they were deciding about preferential, because making a payment to them, again, it is an unsecured creditor. He's the one who is he is bypassed the section 53, and it is the section, as per section 53, he has even if he's got the money, even after a order of the court. So what the judgment has said, that even if there is any transfer of any property, and when you look at the exceptions, as you can see on your screen, is any which is made in the ordinary course, or any security interest, or was used by the corporate debtor to acquire the property. But it has also mentioned, see, one very, very important line, provided that any transfer made in pursuance of the order of a court shall not preclude such transfer to be deemed as giving a preference by the corporate debtor. So what they are saying, any transfer made in pursuance of the order of a court also shall not preclude that transfer to be deemed as giving preference by the corporate debtor. So in fact, that has also gone into detail. They have, the deeming fiction has come into play. So yes, simply said that it's an order of the court, it was not preferential. But then does it fall under the exceptions? Does it fall under the exceptions? The rest is covered by the deeming fiction that has gone into the NCLAT in this particular, even in the JP Supreme Court order, Mr. Anuj Jain's category, they held that when deeming provisions come into existence, a transaction entered between the corporate debtor would be regarded as a preferential transaction, irrespective whether it was in fact intended or anticipated so. And in fact, the defense they had was, if it's in the ordinary course of business or it was because of a court order, in fact, that has also been taken in detail, that even if there is an order of the particular court, then also that would be a preferential transaction. Now, it is not as simple, it is not as gray or black as it seems, because they, in fact, I would advise everyone to go through this NCLAT order in this matter of GVR versus Pooja Bhari, wherein they have given a undistinguished common flow of the business, even that they have gone into this detail that even if it has been given by a court's order, then also it will be preferential because it has been mentioned in the code as such. So in fact, it is mentioned, the legislative scheme says that any transaction, even under a notice, demand, or threat, will not lose its character of preferential transaction merely because of this. In fact, what they have said, that it is even a court order, and it's mentioned in the code itself, that it will not even preclude any court order if a money has been made. So yes, I think you should leave it to the adjudicating authority to decide whether it is preferential or not. But you should make an application which was, properly, and get a proper audit done of the particularly same, and then treat it so. Because the final answer, whether a transaction is preferential or it isn't, would be decided by the adjudicating authority. So you have to make that application. Whether the adjudicating authority allows it or not, that is something which needs to be kept in mind. So.
Brilliant. In simple words, it is this. It depends upon the facts of the matter. So the appropriate person is the adjudicating authority. So, madam, why don't you just, Vaishali ma'am, it is for the, Mr. Junjunwala, the fact of the matter is you may appraise the adjudicating authority so that they can
Yes.
take an informed decision. And we all, the entire things will follow that.
And in fact, you should see the section itself is saying, in where it is given that the even transfer made in pursuance of the order of a court, will not preclude that transfer to be deemed as giving preference. It would still be preferential. That is what is given in the code itself. So, but it is, of course, the adjudicating authority to finally decide.
Yeah, that's fine. Perfect. And
Right.
we have to go to the next question. We have a few more questions coming up. This is from Madam Vaishali. If the assets under avoidance IA are assigned, the IA can survive even after dissolution. Is this right? Absolutely. Madam, over to you.
Yes. Yes, of course, the IA will survive once it is assigned. The only problem, in fact, a lot of assignments were being done. I am in the process of assigning right now before the avoidance gets adjudicated. But the problem was this particular order which had come, which is there on your screen, which of assignment of NRRA, that IA survives. But when the particular person whom you've assigned it to, if in this particular matter, when that person wanted to come into the shoes of the RP liquidator, that was what was not allowed. He filed another IA to say that these IAs will be pursued by a third party or an assignee. That is when the bench declined to substitute the assignee in place of the liquidator and dismiss their applications. So that application would continue. But besides this order, there are certain other orders wherein it has been allowed. The NRRA has been allowed. But yes, about a year and a half, because of this particular order, there was a lot of gray areas, and the NRRAs could not be properly assigned for about a year and a half.
Another question, Madam, adding to that. Once the company is dissolved, how are you going to treat the amount which you are going to get after that? I hope 53 will prevail in that case.
No, that is something, not only 53, also this particular regulation which has been added by IBBI, Regulation 44A has been added, where the stakeholders consultation committee will decide that how firstly they will be pursued and how will these proceeds be distributed. So this is something to be decided by the stakeholders consultation committee. Usually it should be by as per section 53 only, because that is as per law. But of course, with this regulation, the stakeholders can also decide how will be pursued and who will be getting the proceeds from this particular distribution.
Pooja, I will just interject here. Sir, Shankar sir, just give me a second related to this issue. Any clarity on how do you value this NRRA? Because, once you assign, how do you value this assignment is something, I think extremely difficult. Say, the avoidance value is 50 crores and you are assigning it for 2 crores. So, how do you value this NRRA?
That is one major question and one major gray area which is there, especially how to make yourself as a liquidator safe. What you should be doing in an NRRA, that is very important. And I mean, in these days, the quotes which I am getting in assignment of NRRA, I'm right now currently doing one. So all of them are in the percentage of distribution only. That, we'll 50% we will give to the stakeholders, 50% we will keep. Some are saying 20-30, 20-80, some are saying 60-40, some are saying 50-50. So the fact is, the market for these assignment of NRRA has not developed much. There are certain only
So
4-5
nobody's valuing
people.
the NRRs.
Yes,
Nobody's
and
valuing it.
nobody is ready to give any amount, any upfront
Upfront.
amount. Many of
Right.
them are giving, most of them are saying as a percentage of division. Now, I mean, I recently in one of my matters, I got 5 or 6 proposals. All of them had various degrees of this much upfront, this much percentage. Now the stakeholders have said, no, you please tell them, give me upfront only, or give more upfront or give less of a percentage. So, like I said, this is still being explored. This is a new area because for about 1.5 years, it could not get adjudicated a lot of NRRA applications because of that particular one order. Now, recently things have started moving. In July 24, there was one order which I read where an NRRA had been assigned. But yes, how can you value? And how can you value in avoidance? You
No,
cannot.
absolutely.
I mean, if you file an application for 20 crores, you cannot say that its value is 1 crore or 2. In fact, it
Absolutely.
should not be valued also.
Yeah, true.
In
true.
fact, this is nothing which can be done because valuations are done in the beginning of the CIRP or the beginning of the liquidation. as an NRRA, we cannot or should not even attempt to get that question. But yes, the valuation comes from the point of view of the stakeholders. Which one should they accept? Because they have to apply their mind. Some would give about, let's say, 10% upfront and a lesser percentage. The other would give more upfront and a higher percentage. So it is for the stakeholders to now decide, because the regulation says it has to be in consultation with the consultation committee.
Yeah, over to Shankar, sir.
Yes,
Uh,
sir.
So Pooja, just one thing. In this regard, I have a query. So like you said,
Yes.
in one of the cases, NCLT or maybe NCLAT decided that the 26 crore of this very buffet transaction or NRRA, so this was assigned at 50,000 rupees.
Yes, sir.
And this was actually ordered by the court that you cannot actually assign NRA till the amount is adjudicated or it is
Yes.
crystallized.
Yes, sir.
So now, what is actually the jurisprudence in this very context? So,
This is the
so
only,
how,
sir,
at what stage actually we should assign this?
see, now because of this particular order, like I said, I've had to take 4 extensions of my liquidation period because the avoidance is not getting adjudicated. Because it is not getting adjudicated, I every time file an application for extension. So now after 4 years, and no fees. So finally, the stakeholders are like, let us explore, irrespective of this particular order, let us explore NRRA. And I am doing it. So let's see how it goes about. There is one recent order in July 24, which had come, where NRRA had been allowed. And but like I said, it is this is a gray area and it is being explored right now. So let us see where the jurisprudence goes with it. And I specifically went ahead now to even attempt for NRRA because the court asked me, why have you not tried the NRRA route? So then we realized that yes, they may be open to that particular route also, because we ourselves are thinking, we take a judgment, put it in our, in our head and think that because of this, we cannot move ahead. So the court, when they asked that, why are you not moving ahead? So then immediately I, published a notice for inviting EOIs for invitation for not readily realizable assets. So yes, it becomes problem. Everyone thought that it would be, NRRA would be a solution to the avoidances which are not getting adjudicated. But unfortunately, it is not so. It has not really happened up till now. So let's, we can all try our, hope that the gray
Pooja,
areas do
should
get
we
sorted.
treat this judgment? So should we treat this judgment wherein the judge has ordered that one should not actually assign before the crystallization of amount? Should we treat it as a one-off case only, or maybe? So if we as RPs or liquidators, so if we
Yes.
actually wait for the adjudication in case of the
Yes.
profit transactions, I think this will take
Yes.
years and years, and we won't be able to assign.
This is the problem. This is the problem why liquidations are not getting completed. So yes, I would have hoped that this judgment in the NCLAT could have been reversed. It actually did not get reversed. Certain part of it did, certain part of it didn't. Then recently in July 24, there was this judgment in the matter of OBC versus pellet energy system. I was reading through it.
Okay.
So in that particular matter, before adjudication, it has been assigned. So now because of that, it has come. So it becomes easier for us. So I will be using that particular judgment to quote before the NCLT that before adjudication, the avoidance can be assigned. So this is one judgment which has recently come in July.
I think,
It was on the
Pooja,
3rd
let
of
us
July.
complete.
Can you spell pellet? Can you spell
Sandeep?
pellet? What is it?
I will share that judgment. It's PELLET
Okay.
Energy Systems. Yes. So this was in the
Okay,
ma'am of liquidator of ma'am Reshma Mittal. The order was pronounced on 3rd of July 2024. This is New Delhi Principal Bench.
I think let us complete
Okay,
the questions from chat box.
Yes. Yes,
So
please.
then we can come in.
Question. After that, if time permits,
Yeah,
we'll.
yeah, correct, sir. Correct, sir. Correct.
So, Amrendan Shivakumar, the question he has is, in a CIRP, the promoter had withdrawn a large sum of money, 5 crores, and RP had filed the recovery of this amount under PUFE. NCLT suggested that since this is a recovery suit, we should withdraw the application based on the underlying principle evolved in IBC, that NCLT is not a debt recovery forum. Oh my God. Hence, RP based on NCLT remarks had agreed to withdraw this application in hearing on March 21, 2024, and NCLT passed orders permitting withdrawal of this application, with liberty to initiate recovery proceedings against the erstwhile director by promoter as per law. However, RP unable to proceed as instituting proceeding at High Court will involve 3% court fees, which COC was not funding.
Okay. So, if this money was, you saying, withdrawn during the CIRP period or before?
Before.
It was withdrawn before the CIRP period.
But then, sir, then it is a preferential transaction, and that is exactly what I had fought in this the same manner. This is the same facts of the case in my matter, which was of NTL Electronics, Pooja Bari versus NTL Electronics, and which has been upheld by the Supreme Court. So this was the money which they had withdrawn during the CIRP period only. I'm sorry, before the CIRP period. So this is that particular preferential transaction. This is what you can see on your screen. The corporate debtor was NTL Electronics. They had withdrawn money and it has been upheld as a preferential transaction and upheld by the NCLAT and by the Supreme Court, for which I was just saying that now they file a PG matter. But you cannot file recovery against them, sir. If it is within 2 years. See, if it is depending on the time frame, if it was prior to 2 years, then yes, then it becomes an issue. But if it is within the 2 years, it will fall in the category of preferential transactions.
It was prior to 2 years. It's over a period of time, and it's very, very difficult.
Yes.
Being the promoter who practically ran a residential real estate company,
Yes,
he just
yes.
ran it up, and there's a lot of number 2 transactions in real estate, this and that. So he just put it up and was claiming that I don't have to pay this because I have incurred all this cost, and I can't tell you why.
And what was the COC? What do they say about the expenditure?
The COC is 97% real estate allottees, and they couldn't care less. I mean, the CRP is still going on for 5 years. They don't want to go on to High Court. Their faith is very, very low in putting in 15 lakh rupees, and God knows how long that will keep getting adjudicated.
No, sir, any recovery suit will take years. In fact, I've been trying to fight with the
if I may interrupt, I also got a recovery ruled in our favor from a leading bank for taking money during the moratorium. And that also we got an NCLT order asking them to reverse the transaction, but they have gone to NCLAT. And NCLAT at Chennai is a very, very busy place. Those hearings are still ongoing, So again, it's a pretty hopeless case.
So what about when was the withdrawal? Was it 3 years before limitation getting hit here?
It's very difficult to point out, but it's at least a period of 5 years. These things happened from 2013 to 2018, and the CRP started in 2019.
Okay.
September 2019.
If it is beyond 3 years, your chance is even low.
That's why I politely accepted when they told me verbally, and I was happy that they at least permitted me to go ahead and file in the appropriate forum, which is High Court, because of the amount of the transaction. Okay.
Then you should minutize it, sir. You should minutize it in your meeting that nobody has. You put up that agenda.
Yeah, I have put that up. I put up a resolution asking for permission, and I also put it up in the next meeting that I'm not going ahead anymore because nobody has come forward to fund this.
Yes, so that's it. In one of my matters where I had to recover from debtors, and they were government debtors, I placed it before the COC and the expenditure. I placed it in 3 COCs. All 3 times they rejected. So now if anyone asks me, why didn't you file an application for recovery? I have that I did place it before the COC. The cost would be a part of CIRP costs. They refused for the same. And accordingly, that is something which is taken cognizance of the court. So now I'm fighting it in the liquidation now. So
in my case, my case, they didn't refuse. They just simply abstained from voting.
Abstaining is also not, as long as you don't have positive votes to a particular percentage, it is, you cannot move ahead with it, sir.
Yeah, it's pretty. Sorry to intervene on this.
Are you funding for the litigation cost also from your pocket?
No, I'm not funding anything from my pocket.
Because in my case, I am forced to fund from my own pocket. In one of my cases, it is Intech Capital, to name this, and CRP is running from around 3.5 years. Now I'm appointed as a liquidator.
and I located one FDR in a liquidation application and move for the recovery under Section 40, given a understanding of Section 42. Now he's disallowing the payment that now I'm not able to pay. You just recover from the FDR. I filed an application before the NCLT, and he is lingering on the applications. Sometimes he changes the counsel, sometimes he's not putting his attendance, and now more than sorry, to be very precise, 17 months have been passed on. Extension application has been filed by me, which has been approved, but I am nowhere. 1.5 years, my fees is not there. Liquidation cost has been borne by me, but now I have to file two-way transaction. For that, advocate is asking for the past dues, and if I am hiring for a new advocate, is asking for advance money. I don't have the advance money, so I am putting for the liquidation cost. What is the fate of this profession? I'm just going ahead with this, and in tech, always say my account is also NPA, so do whatever you want. In past a week ago, I filed a contempt application. Now it is pending before the adjudicating authority, and God knows what shall be the next step forward for this.
Thank you for the feedback. I'll just going to Shivma sir, I think you have done the right way, right decision by putting in the minutizing and all those things. I think that's the best thing which we can do. I'll move to the next question. Miss Madam Vaishali has come up with another question. But RA will incur cost in pursuing the avoidance IA. Whether the cost can be recovered by RA before distributing to creditors.
Usually it is done that the same way only. Usually when they are giving their proposals, that how the money will be distributed. So they usually write that the after deduction of the legal expenses, we will be distributing. And that's what I have also done in my matters also. That is something which is usually given, and because as you can see on your screen, they will have to, as per this, the plan itself, the RA will have to say how it will be pursued and how the proceedings will be distributed. So, and they always have the right to say that the expenditure will be reduced first and then divided as per Section 53, which is the usual stance which is taken by most of the RAs.
Yeah, that's it. Yeah, we'll move to the next question. That's by Mr. Bhupendra Sethi. What are the challenges in collection of evidence on support of avoidance application and how it is mitigated? It's very, very macro question. It depends upon the case to case. But madam, I would like to you to just comment.
Like you said, sir, that it depends on case to case. If you have the level of non-cooperation, if they are cooperative, but still they would not be giving evidence against themselves to you, but it is for you to, ensure that you try your best. As an RP, you also have the powers to get information from various creditors. And it's not necessary that it is only the corporate debtor or the directors who will give you the information. I've actually had cases where my fraudulent application was based on orders of the income tax because they had done their investigations, or there were some GST orders wherein they had done their investigation, and in that investigations I got the proofs of the frauds which had been done, and then there were various others. So it is, as an RP, you get whatever information you have. You're supposed to be reading all the information which is given to you. Ask information if there's any audit which has been done by the creditors, the COC members, whichever are the creditors, if they are not assisting. But then there are cases when no one has the information, so you are left in the dark. In one of my matters, the information which I have is of 2020. They have not given me information for the past 4 years. So what I had to, in a way, get an audit done on basis only of the bank account details which was available, and it was a big company. And of course, then there's a disclaimer, and of course that disclaimer is going to be used by them when I file the application. That these are not based on the actual audited accounts, because I, as an RP, do not have audited accounts for the past 4 years. So there are issues. Every case is very different. Not necessary that every case has an avoidance. You could say out of 10 of my matters, 5, there were no applications for avoidance. So for me, it's been 50-50. 50% of the cases, there have been avoidable transactions, and another 50, there have not been. So it's not necessary that in every case there would be, I think we have to take full efforts to get as much information as we can and make the complete efforts to get the information. That's it. Every case is different, sir.
Absolutely.
Every case is totally different, sir. I mean,
Yeah,
that much I can say.
that's true. And the regulation always says the word forming an opinion. So forming an opinion is based on facts, figures, evidences. So enough is not enough in certain cases. So
Right.
more the information, more the merrier. I mean, when you present before the NCLT, you put forward your statement, application of mind should be proven, and forming an opinion has to be supported by documents. That is the essence of it. Madam, then there are a lot of, at least a dozen of compliments to you, and one says you are
Thank you.
as good
Madam Pooja, I do have a question, if you
as
allow
Yes,
me.
please, sir.
Subrato
Please,
ji,
sir.
Subrato ji, one sec. I'll get back to you. Subrato ji, just give me a minute. I'll get back to you.
Okay, sir.
Yes,
I'll
yes, please, sir.
completely get back to you. Another thing, Mr. Swaroop Ghosh says, nowadays bank pressurizing the liquidator for early dissolution day, so that he's giving an opinion that nowadays CDs is managing the bank first, and banks pressurizing the liquidator to file early dissolution on the pretext that nothing happens in life in application. Refer history of NCLT about ineffective of PUFE. He's just making a statement. It's nothing but fact. And the other one is about 50,000 rupees, which you have mentioned. Then the last question is from Sarvesh Kashyap. He says, can promoter participate in auction during the liquidation if promoters are ineligible under section 29A and A pass the order? Madam, you have mentioned that, but then for the sake of clarification,
Yes.
can you put your
Yes,
word?
as per section 29A, only an avoidance which has been adjudicated is then you become ineligible as per section 29A, as per my understanding. And they will be able to participate if they are compliant with the other provisions of section 29A. So it's not only avoidance, there are other provisions also which are there. So anyone who is ineligible as per 29A would be ineligible to buy an asset under liquidation. So, and yes,
Pooja, if you can permit me, I can come in.
please,
Okay,
please,
can you
please,
just
sir.
yeah, please
Can I
unshare.
stop my share? Yeah.
Yeah, that will be better. Yeah. Okay,
Yes.
see, this is the particular case. You see, I fought in Chennai NCLT, where the law is very clear. What you have said, that if the person has been held guilty and an order has been passed for recovery of money, only then he is ineligible under section 29A. But having said that, in one of the cases, the promoter submitted the plan and there was a pending application. Now the judge was confused. He said, Mr. Makija, what to do? I said, my lords, now you need to decide which application you want to take up first. And according to me, if you ask me, my opinion is you must take avoidance application first. Because if you pass an order, then probably this person can become ineligible. So he agreed with my view. He says, is there any jurisprudence? I said, yes, there is a jurisprudence. The matter went to the Supreme Court, and Supreme Court on one of the days said, in that judgment said, we will decide it some other day. So they said, okay, first the NCLT, let NCLT decide on this. So that's what I can mention.
Sir, one more, I'm
Yeah.
sorry to interrupt, sir, one more view that in the case of one of my case in Mumbai, the identical situation arises when the bench member have said that since the PUF application are pending, we are not going to approve the resolution plan. So, and that in that situation, the COC has called one meeting and they have given on affidavit in writing that we are withdrawing the PUF application. I don't know whether it is permissible or not, but that is what had happened. And the bench member has passed the resolution plan thereafter.
No, that's not a correct way of looking at it, because let us also understand one more thing. There is another view, but the view is because Supreme Court has said in ArcelorMittal versus Satish Kumar Gupta judgment is a landmark judgment on 29A. What do they say? They say that the eligibility criteria is to be seen on the date of submission of the plan. Now, the question is, if the application is filed later on and they are held guilty later on, whether they were ineligible to submit the plan or not. So this question has not been answered so far. I think one day or the other, Supreme Court will answer that. But first, of course, it has to go through NCLT and CLAT or whatever, all the processes are there. But it's a great question. I think we will
Sir, in
also...
the similar case, I guided the COC to either withdraw the Section 66 application on a filed affidavit because I am not going to withdraw on under my affidavit. So COC was agreeing for 12A or 29A plan as per the exemption 29A. So COC minutize it that we are eager to withdraw Section 66 application and directed that RP to withdraw the said application, and then.
But Ankur, there is one more aspect which Pooja will also agree, because the point is your duty is to form an opinion, determine and file. It is your mandatory obligation.
Yes.
Now,
Yes.
COC has no role to play. In fact, there are IBBI disciplinary committee judgments are there. Where is the, why did you approach COC for this? So I don't think
Exactly.
COC has got a role in this.
No, COC has no role in it at all. In fact, in one of them, the COC put an agenda that I cannot file an application, and I did file it because there was huge amount of fraud, and the COC was not only banks. There, of course, because you have to consider sometimes COCs are not only banks and financial institutions. There are other, you could say, companies also who are financial creditors who form a part of your COC. It is a possibility that COC tells you no, you cannot file. There are some who tell you don't do the audit, some who tell you don't file the application, but it is your duty to tell the court that it is my duty as per a particular section. I have to file it. The COC has no jurisdiction to even say that whether you should withdraw it or not, because till an application actually gets filed, can only be withdrawn by the RP. And I would always advise an RP never to withdraw such an application. Never. Yes, because you are then yourself calling upon yourself disciplinary action, which from IBBI or from your IPA.
Absolutely.
Quite dangerous that you are agreeing to COC's, opinion in that case. And there are 5 hands being raised. First, I'll start with Mr. Subrato Ghosh. Sir, can you make it very, very brief? It's only 12 minutes
Yes,
left.
sir. Yes, sir. Thank you, Sankarji. My submission is that I am a liquidator of a company which is, gone into liquidation just before 5-6 months ago. But before that, in insolvency time, it was in 2021. But before that, there is nothing no record. Last audited balances was 2015. Now, so there is no transaction report, no PUFE application, no non-corporation application, nothing I received from the earlier RP. Now, as a liquidator, I saw there is a land mortgaged with the financial institution, and that fraudulently the SBOD has made a development agreement with someone and took money and one portion of the flat. But right now, how can I proceed? Because I don't have any MOM, nothing, MOI, nothing is there. But my duty is to report to the NCLT as well as to the stakeholder, because most of the flats are sold, 80-90%. They are also in trouble. So what is my view? View is to resolve the issue. So what should I do? Should I ask for the reversal of this transaction, or should I go for the solution for selling to the existing home buyers and also the unsold flat to the auction or amicable sale? It is a question to Pujaji or any other who can give some idea regarding this issue.
I think Makhija ji would be the right person to answer this for it's a home case. But I think it is best is to ask the advice of the NCL team themselves. That like I said, every case has very different facts and circumstances, which we may not be able to understand the details of a particular matter right now. So it is always advisable, sir, to ask the adjudicating authority that give them the facts and then accordingly draft the prayer. Because yes, it could be an avoidable transaction, which could be undone because it could be an undervalued transaction. It could be undervalued. It could also fall under fraudulent. Yes. So these are the two heads it can fall under, whether it is undervalued or fraudulent, both. So that will have to be seen. You will have to do a proper audit and then make an application to the NCLT and then ask them. I think, or maybe Mr. Makhija also, if you can just put in.
It is not possible because there is no record. 2015, after that, the SBOD is also deceived. right now the next one is his wife. She is also, another stakeholder, maybe 5%, but 90%, 5% who is holding was deceased now. That is a problem.
We will not go into the deep facts. Just one question, one process. The process is you are a liquidator at this point of time. Therefore, put it up before SEC. Seek their opinion. The code has empowered you to go against the advice. Meaning, if you are acting against, you are at liberty to act against the advice of this SEC also. So first make up your mind whether, even if it is 1% chance that you feel that there is an issue, put it of SEC, take it of NCLT, and close this matter. Let the NCLT.
Right, sir, but SEC already I have discussed. SEC do not want to go into the litigation again. They want to get some money out of it and resolve the issue.
You got the point. That's good. If at all, still, if you feel that there is a matter in it, some crux in it, approach NCLT.
I am worried about the disciplinary action because earlier RP also did not do anything. If I do not do any report this matter, so that's why also. That is also my point of view.
That you have raised with SEC, you have to take a call, either yes or no. Stick on to that. If you want to take no, go ahead with NCLT. Let come.
Okay, thank you. Okay, I will do that necessary because it is related to both money realization as well as that.
Yeah, peace of mind prevails, disciplinary proceedings prevail. I agree, but end of the day, go ahead with NCLT. That's the best thing. So I see.
Next time.
And also maybe file an application, a complaint with IBBI if you think this, if there are any relevant sections, section 70, 71, 72, 73, where the data has not been provided to you. So that's a criminal liability complaint, which you can file and you should file. First, please see in the facts of every facts of your matter. If you feel, then you can file, sir.
Yeah, section 68 to 74. 68 to 74, go through that. That will help you.
It is against the SBOD because yes.
Thank you.
Okay. Okay. Thank you, Sankarji. Thank you, Pujaji.
Thank you. And I see Mr. Vishwanath's hands being raised for some time now. I'm sorry, sir. Are you there?
Yeah, very much here. Pujaji, that was so good. Nice. Thanks to you. Maybe the question looks preliminary, but as per your experience, what do you think is it better to appoint a transaction auditor? I, being a CA, do the transaction audit myself. The reason is the financial creator always harps on the cost involved.
50% of my matters, I did not need to appoint an auditor. But then when the documents are huge, when the transactions are large, or when you feel it is a bigger issue, then in that particular case, you should appoint a forensic or a transaction auditor. But then in smaller cases, smaller matters where you do not think, where you yourself can also see, if first you need to form an opinion yourself. See, your opinion, which is in tougher cases, bigger cases where there is more complication, then yes, you need an auditor. Not in all cases, sir. I mean, I have not used in all my matters.
Thank you so much. Thanks a lot.
And I'm not a CA. So, even as a person who does understand layman accounts and everyone, I mean, you do get to know, where there is fraud, where there isn't. But then, yes, in complicated, bigger issues, larger number of large volume of entries, yes, then you must get it done.
And one more small question.
Yes.
Whether the extension period, the relevant period can be extended. And if so, what is the...
So which relevant period? Are you talking about
2 years?
75?
2 years preferential.
No. The look back period is either 1 year or 2 years, depending whether you're a related party or not related party.
So we should go
For
ahead.
an unrelated party, it is 1 year. For a related party, it is 2 years. For fraudulent, section 66, there isn't any look back period.
Okay, so only 66 would be available if it were. Okay,
Yes,
thank you so much.
Yes.
Thanks
Most
a lot.
welcome.
Thank you. Thank you, Vishwanathji. I'll go to Mr. Modilal Pamecha. Sir, please.
Yeah. Good evening, ma'am. Pooja ma'am, I think, hope you recollect me.
Yes,
Yeah.
yes, I do, sir. How are you?
On your matter, similar matter, I am also handling the same matter which we discussed, I think, 2 years back when the SFI was going on.
Yes, sir.
Finally, that matter only now section 66 application has been partly allowed. Now, my two questions based on that discussion, SFI investigation is going on. Section 66 is partly allowed now. Whether after filing of the resolution application, when now we can go for the NRRA, taking that as an order as a base, whether any buyer can come after filing resolution application. One. Second thing, after filing resolution application, whether we are supposed to file the progress report also.
Okay, so I'll take your one question at a time.
Yeah.
I think my order would create a bar on you filing a dissolution. My order in GSPAT, which says the pendency of any investigation creates a bar on dissolution. So that is one order of the GSPAT, which may create a bar for you to file a dissolution after your,
In fact, if
your SFIO is pending, number one.
In fact, you
Yes.
recollect we discussed also that you suggested me to file resolution application. So
No, I
accordingly,
did. No, yes, but I don't know. The fact is, my order is was which is there for investigation authorities. Yes, there are other orders also where it has been allowed, dissolution has been allowed, and like I said, every bench is different. And for any matter, you will get four orders one side and four on the other. So if your court allows dissolution, it is the adjudicating authority; they can adjudicate anything. But that is definitely there. But who is going to pursue if there is any further investigation needs to be properly mentioned in even when you're assigning NRRA. If there is an investigation, who will be assisting them? That's a question which if it is there, then I feel, your dissolution may be allowed by the adjudicating authorities.
Thank you. I'll just, short of time, sir, I'll just move to the question. Shyam Krishna Garikapati, sir, are you there? Mr. Shyam Krishna Garikapati? All right. Now I'm left only with my boss. No, he's there. Mr. Shyam Krishna?
Yes, sir, I am here.
Yeah, I think you have raised an, is it a high for madam or is it a high for asking question?
No. I haven't raised anything, sir.
Great.
Please go ahead with others.
All right. I can see the hands there. Fine. Thank you so much. Now I will return to my friend Vikram to carry forward with. Madam, it was wonderful to hear you again and again. Thank you so much. It would be nice if you can just share the presentations in the group if possible.
Yes, I will do the needful, sir. Definitely. Thank you. And thank you so much for this opportunity. Thank you so much. Thanks again.
Pooja, you're not done yet. You're not done.
Over to you.
Not yet? Okay, okay, sir.
Actually, I had many points to make. Unfortunately, time is not permitting. So, given the limited time, I just wanted to raise one point. Section 66(2), which is the wrongful trading, which basically talks about a director not exercising due diligence. So, have you had any experience of using 66 subclause 2? Because most of the RPs are not using this clause of 66 subclause 2. I actually wanted to request you, if you had an experience, please share. Or if you can give an example of 66(2), I think it will educate all of us.
66(2), in fact, like I said, with the matter which I discussed, GSPAT, it had both ingredients of 66(1) and 66(2). 66(2) was primarily because when they knew that they were on the downhill, they still kept on taking more and more credit in this particular matter, and they had written that we knew we could not pay to the banks, so we inflated our stocks to give a stock statement to banks to get more credit, so that despite knowing that they were going towards being a non-performing asset, they deliberately inflated their stock statements to get more credit from banks instead of rationalizing and trying to take decisions that how you can actually pay back your creditors. So that was one example of 66(2), which I use in my application, for which now the MC investigation is ongoing, sir. And that is how I came to know, was because there was a particular order of the VAT, wherein they had admitted that yes, we were giving fraudulent stock statements to bank to get a higher amount of credit, and then the circle all began, and which is still pending. The MC investigation is still pending 5 years.
One last query, Pooja. Since Dr. Makhija is also here, I wanted to use, his brain also.
Yes.
That, finally the order is there of the court, putting the director responsible and, paying the dues back based on the order. But the director files a 94 application. Finally, he becomes a bankrupt. Then what is the fate of this application?
Yeah, that's what I discussed in the presentation, that this is a gray area. So,
So
Mr.
I think,
Makhija, if you can answer, yes,
Dr.
that would
Makhija
help
can
me
give
in the
some light on this
application which
issue.
I am fighting in the court right now to, to close this issue. It is there. It is, I'm fighting this application, sir.
Okay, see, there are two things. Let us understand. A person who becomes insolvent, naturally the claims have to be invited, and he submits a repayment plan. So at the stage of insolvency, nothing is stopped. The question which you are asking is probably is more relevant for bankruptcy. That when the person becomes a bankrupt, what will happen? We have to typically look at the definition of excluded assets, right? Or excluded debts, not excluded assets, excluded debts. Excluded debts, I think my friends will recall. You see, it is very simple. We call it as FDMLA, right? That acronym, if you remember, that is very, very important for us to. So F stands for fines, D stands for damages, L stands for student loan, or then M stands for maintenance, and A stands for the any other debt. Now, the any other debt as may be prescribed, which central government has not prescribed so far. So, having said that, whether this court judgment falls under any of these, the answer is no. It is not neither a fine nor a damages. It's an
So
order for
that's what I'm
recovery.
fighting for. That's what I'm actually fighting, that it is an extension of the fine and damages ordered by a court. And an adjudicated avoidance should fall under the category of fines and damages, because when it came into being, when the PG, when that excluded debt, they did not go. In fact, I believe a lot of changes are going to be made in the law with reference to this. I think IBBI is going to be giving a clarification. Till it comes, I am still fighting the battle that it should be a part of fines and and an extension of a fine imposed by a court, because it is NCLT is adjudicating authority. It is something adjudicated by them. So that is something which I am right now trying to fight. So I don't know how it goes, but it is still pending.
Okay, legally speaking, if you ask me, fines typically cannot be imposed by adjudicating authorities or any tribunal. They can be imposed only by the courts, whether it is a civil court or a criminal court, typically criminal court. Because if you see Companies Act, where the offenses and penalties say fines or imprisonment. So fines are imposed as an offense. So this is not an offense. This is a civil liability for recovery of money. That's a recovery order. Whether it can fall under damages, I have my doubts, because it is not a damage. Damage is like somebody has done negligence and some damages are awarded. So this is not a negligence kind of a thing. There is a diversion of money or something like that. So having said that, according to me, they will not fall under excluded debt. Of course, the judge and adjudicating authority can pass any order today, but ultimately will wait for the Supreme Court. So I am of very opinion that this cannot be done. So having said that, if it does not fall under excluded assets, then whatever are recoveries made and whatever the claims are there again. So this is nothing but a claim. So if you are able to satisfy, fine. Otherwise, he gets a free bird. He gets discharged after a period of 1 year, as far as the bankruptcy provisions are concerned. So that's my opinion where we stand as of today. Okay. I think it has been a great session. We are already crossed our time limit. I think if there are no more questions, Vikramji has got a benefit. He definitely can get offline with Pooja and ask as many questions as he wants.
Mukhya ji, I do have a question,
Anytime, sir.
if you can allow me.
Sir, you have to be
I
very
am
quick, sir. We have already
exceeded
crossed
the
our
time,
very
time.
sir.
brief, very brief, if you allow me. Otherwise,
No, no,
I'll.
no. I think Mr. Shankar Panikar has to permit you, sir. मैं भी आज guest
Yes,
ही
yes. Yeah. Shankar ji, I do have a question, small question. I am a alpha liquidator, another company,
His name
very
is a
small.
football player, so I am allowing, sir. 1 minute.
Okay, actually, thank you. Actually, I am also a liquidator of a company, which is liquidated to 1 year ago. But before that, it was under, CIRP, but nothing has been concluded. And only my earlier RP has filed a non-cooperation clause 19.2 against the SBOD. But SBOD is not handed over any asset. They have a book last was 21.3. That was a asset of, consist of stock, cash, liquid cash, and also some portion of, fixed asset, like plant and machinery, also car. But he has not handed over a single case. So only 19.2 is going on against that SBOD. What else I can do against him if it is at all required? Because otherwise I am not getting any handover of asset. So valuation also not been done till then. Not even in CRP. I have appointed valuer in liquidation case only.
Madam, over to you. My answer would be very clear. File a application for early posting and finish it off. Before the
Early?
sir.
Early?
File an application before NCLT for early hearing of 19.2 and finish it off. And at least you have got some clarity.
Okay,
So
again,
yes,
I'll
like I said,
I'll do
19.2 is
another filing
important.
for
No, no.
19.2. Okay.
So 19.2 is important. Filing your complaint in the IBBI is important regarding the sections which I told you, with section 68, 70, 71, 72, 73. You should do that. I think it is very important for you to, ensure. And if you can, with the statement of accounts, try to reconstruct the books to get an audit done and then file an application. It is, if it can be done, please do the needful. Because I did that, like I was explaining to you, then one of my matters, the last accounts I have is of 2020. So I have nothing. And it's a huge company with 600 employees, 600 crore turnover, but I had nothing. So only with the statement accounts with limited, I've been able to reconstruct so that I will be able to actually file the application for avoidance. That's it. So
Yeah,
if there
I
is any,
understand.
yes.
I have asked for the tally data or records. He has not handed over a single piece of
You
report.
can get the
That is the
bank
problem.
in the bank statements. You can get, if you know which are the banks which are there from the MCA. There would be something on the uploaded on the data. So you get and you write letters to the banks and try and get the statement of accounts for the past maybe 2 years or 3 years or 4 years, and try to get an audit done basis of the statements if you can.
Okay. Thanks
Thank
for
you,
your
sir. Thank you,
okay.
sir. Thank you.
And early application also will help. I'll pray for that also, for the early hearing. Thank you. Panikatji, thank you, Pujaji.
Wonderful.
And thank you, Asisji, for your.
Thank you, sir. Vikramji, thank you so much. And I'll request
I
you
think,
to.
now over to Namrata to
Yes,
carry
sir.
on the proceedings.
Yes, sir. Thank
मजा आ
you.
गया सर, आज मजा आ गया.
Thank you to our lead speaker of the day, IP Pooja Bhadri, for her sharing her insights and experiences with us. And a very special thank you to our moderator coordinator, Mr. Shankar Panikar, sir. I would like to thank all participants for your participation in patient hearing.
Ma'am, are you sharing the PPT?
Yes, I will be sharing the PPT with IPNet and then they'll share it with you.
Yeah, it will be helpful. Thanks, madam.
Thank you, sir. Thank you.
Welcome. Many thanks for nice presentation. And give the all.
Thank you very much.
Thank you so
I think,
much.
friends, let us wait. I think Namrata has to say something.
One more announcement. Yes, we have
He's
to
thanking
now we're looking
you
forward
see
to the
the
next.
speaker on behalf of everyone. Okay.
Yes, I'm thanking everyone and thanking all the participants. And now we look forward to more such webinars where I call forward Mr. Ravindra Chaturvedi, sir. Let us know about the next webinar.
Thank you, Namrata, and thank you, IPNet team. So next seminar we are going to conduct webinar. We are going to conduct on Dasera on 12th of October. So the subject is role and responsibility with opportunity and challenges of the insolvency professional as AR in real estate insolvency. That topic is very important, more so because of on 24th of September there is one amendment wherein the concept of interim representative has been introduced. So and there are many other opportunities for insolvency professional as a AR. They are facing a lot of challenges also dealing with so many home buyers. So we will deal and discuss what are the opportunities available. We are facing challenges, what are the role and responsibility and so on. And we have requested a prominent speaker as well as Mr. Harihara Mishra, who has keep writing on newspaper on various topics on the stress assets, including IBC. So he will be our chief guest on that day. And Mr. The Harshad Deshpande will be the speaker for that day. Thank you. Over to Namrata.
Thank you so much, sir. We look forward to the webinar and our best wishes with you. I would like to now invite the member of HIPA to propose a formal vote of thanks and appreciation certificate to the speaker and moderator of the day. Vikram sir.
So who is representing from HIPA? I think.
Sir, I would request, Vikram sir, I request you to kindly take this forward.
Suhasini is supposed to be
I
there.
think Suhasini was supposed to, represent from
Okay,
HIPA.
I can thank on behalf of HIPA Hyderabad. I was the founder president. Thanks a lot. And it was a privilege to have my question answered, which is very tough practically. And thanks a lot.